Well, I can just start and generally discuss the different categories of intellectual property and what intellectual property is. Intellectual property is basically the legal protection that that you use to cover your ideas of the mind. Copyrights, trademarks, and patents. It's not tangible property, so you can't really see it per se, but it covers either where your goods are sourced from, the copyright protects original works of authorship, and then the patent covers your inventions. So those are the three main categories of intellectual property. And we started this event so that people would be able to come in and meet us. And intellectual property can be really, really overwhelming because it's very, very abstract. It's not, you know, you can see a piece of property, you can see a car, you can see somebody's purse, you know that that's real property. But intellectual property is very abstract, and a lot of times it can be hard for people to understand what exactly it is. So that's part of the reason that we started up Pirate Fight Club, just to kind of, for educational purposes, so that people could understand different aspects of intellectual property. So I can go into the three main categories are patents, which I've mentioned. They end up being in the news a little bit. They cover inventions. So if you've got an improvement on an air conditioner, then that would be covered by patent law. If you've got you know, solar panels, things along those lines, that would all be patentable. All the cell phones and the technology that goes into your different devices, that's covered by patents. Copyrights cover original works of authorship, so we've got the painting as an example over there, we've got a couple photographs in here. Sculptures, movies, music, all of that is covered by copyright. And then trademarks are a little bit different. They cover the source of goods and services. So when you walk into Spot Coffee and you get your coffee and you walk out, people know that you went to Spot and you didn't get your coffee from Starbucks. Or they know that you went to Dunkin' Donuts and you didn't get it from Tim Hortons. So that's what that does. Almost all the big companies have trademark protection. And what that does is it actually protects the consumer from confusion. So you understand very much where your coffee is coming from, or your sneakers, or your car, or whatever the different, you're not wearing Nike, but if you were, well, that could be Nike. It is Nike, okay, so you're wearing Nike, so we know that's not from Adidas. And you know, all the goodwill that's attached to that. So when you see the Nike swoosh sign, you know that that's Nike, and they usually spend a lot of money on their technology, so they've got really good products that help you run faster, and they help with wicking and different things along those lines. So that's what the trademark does. The trademarks can be helpful for almost every business these days because the internet is just, it's so easy for people to see what you're doing and maybe take your name and then rip it off and go file for a trademark application at the trademark office. Copyrights would come along and help you out. Are you doing something like artistic?
Yes, if I'm publishing a work that contains a story and also visuals, and my characters, my story, my title, that's all me, just me.
Right.
So I imagine I'd need, the copyright is on the work that they're published in?
Right.
And the trademark is on the name of the...
The trademark wouldn't necessarily cover the name of the book. It has to be a series of books in order for trademark to apply. So, you know, the series of the how-to series for dummies.
If it's meant to be a periodical?
Then the trademark could apply to the title.
All right, from issue 1.
Right. And then the trademark could show up in the name of the publishing house. So Macmillan would be a registered trademark. HarperCollins, those Harvard Press, I think, are some of the other ones. So those are the trademarks, but typically the book itself only has copyright.
Okay, and characters that this series will be based on, their names, their likenesses?
That would be covered by copyright as well.
Copyright, okay, so
Yeah.
I wouldn't need to copyright the names of the characters or trademark them.
You could trademark them. I believe Mickey Mouse is probably trademarked.
Right.
But not necessarily. In terms of the names of the characters, I believe that Mickey Mouse is trademarked, so, but there's a line of goods and services that go along with the Mickey Mouse character, so that's where that shows up from the trademark standpoint. So the copyright at this point, I don't think you need to trademark the names of the characters, but you could do that later if you are selling goods and services under that name. And then business formation, we talk about that a little bit. The business formation, what that does is, you can go down to County Hall and form a DBA, and then this allows you to open a bank account under a separate name, so you can keep your finances separate. The next step from there is actually forming a state-recognized entity. So that's where you go to, in most cases, New York State, and you say, I'd like to open an incorporation, or I'd like to open an LLC, limited liability company. And then what you do there is you can kind of keep your finances and your liability separate. So if you take out a loan from the LLC, and then all of that is paid back by the LLC. And most of the liability will sit with the LLC. So if you're working from home and you have an LLC, and the UPS person delivers something to the LLC and trips and falls on the way out, then the lawsuit's going to hit the LLC and hopefully won't attach to you individually. So there are a lot of benefits to starting up a business formation. Like I said, that's recognized at the state level. You can run all of your expenses through the incorporation or the LLC, and that can be really beneficial from a tax standpoint. So I'm not a tax attorney, I'm not an accountant, but those are some of the benefits. And then if you do decide to do that, you can speak to an accountant to figure out, if that does make sense for you.
And I have this piece that either needs copyright. I've given it to people as gifts, but some of them have been like, you need to copyright it. Or I use other people's names in this, so I don't know if that's necessarily legal to sell it for commercial use, because it's using women's names.
Right.
So I guess I just don't know if this is public information, or I'm sure people could take this idea and create their own as well.
Okay, so copyright protects original works of authorship. So it's sort of the way that you've laid this out here, and the different color choices. The names, she's got, I can show you.
Yeah.
Aretha Franklin for A, Beyonce Knowles for B, and then you get the idea for the rest of the different categories. Obviously, there's no copyright would attach in the person's name, because that's their name. You could file, so in the United States, the way copyright works is that copyright attaches as soon as the work of authorship is in a tangible form of medium. So in this case, we've got this really nice heavy paper. So copyright has attached. This gives you the right to copy it, distribute it, sell it, make reproductions, make derivative works. The trick is, if you ever need to enforce your copyright, then you need to register it. So in some cases, you can register it beforehand. And then that's actually recommended. So you can go to the Library of Congress's website and register your work. It's fairly straightforward. It's one of the few times where I tell you that you probably don't need an attorney to help you. They ask you a series of questions, and then you just answer them. And then you get the registration certificate. So then the other question that comes up, and this is a trickier question, is whether you're using the person's name as endorsement of your product. And I don't know. I think you're okay.
The only thing, and I'm not very good at digesting all of this information when I read it, so that's why
it's very confusing.
Who understands it? But I know that with some artwork, like photographers who take pictures of people like on the streets, that's considered like public information because it's out in the public. So I don't know if like these names are public information for all of us to know.
Yeah, that's a great question. They are out in the public, so if the newspaper prints the photograph, then that's perfectly fine because it's news. But let's say the person's wearing a Chanel handbag and Chanel takes the print and they publish it, then it gives the appearance of advertising.
Yeah, okay.
So then you're sort of, you're relying on their likeness. I don't think you're quite doing that here, and these are just people's names, and they're women, and they're famous women. And then, so you've got the code here, like non-golden is known for photography.
Mm-hmm.
I think this is all public information, so I don't think there's a ton of copyright in here, but it is, the unique arrangement I think does have copyright.
Okay.
I think that you're okay with respect to the rights of publicity issue. If anybody ever said anything, you would just stop creating them.
So I do freelance photography on the side.
Okay.
Mostly editorial because I have a full-time job, so I can't chase customers or clients or anything like that. So if I shoot something for the paper, I believe the agreement, and I have to look at it, but it's basically they'll say, can you go out on an assignment for us, shoot this event or whatever,
Yeah.
and then they'll pay per photo.
Yeah.
Which it's usually just 1 or 2 photos. It's a small outlet. But within that, they'll offer the extra prints or extra photos as prints publicly. And I have a website that I was able to set up that does the same thing. If I go to a school event, so I've had contact with a coach about this. I went to shoot an event, photos for the paper. I post them online as well as portfolio type stuff.
Right.
And then on my website, it's just a default function that I have it set to offer them for sale. So if a parent or somebody wants a print of them, I don't have to bounce back and forth on emails, but I still control if they can get it, so it's not like Chanel can reach out and say, or Nike says, we want to use this in an ad.
Yeah.
I can decline it or whatever, or dig further. The coach had responded to me because they had taken a photo that I posted online. They created a team account that the coach and a few players, high school kids, manage.
Okay.
And they posted a photo, and I just dumbly stumbled across it. It's like, oh, hey, that's my picture there.
Yeah.
How did they get that? So he said I tweeted at them, and that was like their consent apparently to post it. So I just said, no, I'm not gonna harass you guys. Like, that's my photo, copyright.
Right.
I understand that much of it. So give me credit at least. But
Right.
damage is done. Whatever.
Yeah.
And then he countered by saying, well, I saw your website and you're selling photos of these guys, and I was a D1 athlete and we had to sign waivers and you're profiting commercially. Which, at the end of the day,
Right.
I'm not profiting.
Right.
I mean, it's keeping my website functioning
Right.
for the year, if I make any sales on a game. So, if it's a public event like that, and I've seen books in stores where it's street photography, and it doesn't look like there's any names mentioned, there's no photo releases. What are the rights within that, like, as a photographer to be able to do with that work?
That is a great question.
So it starts off editorially, and I'm
Right.
not selling it commercially per se to a Nike or anybody.
Right,
I'm not
right.
shopping it around.
Right.
It's just there for Billy's parents to order if they want a copy of their kids.
Do you know whether a waiver is ever signed by the parents?
I don't know. So,
Okay.
and that's kind of what also was wondering, like, should I be approaching schools and saying, I'm here for news purposes, but if I have these extra shots, I have 300 photos from a game that
Right.
aren't gonna be seen otherwise.
Ideally, you would get a photo release from the parents, and then that just allows you to do whatever you want with it. It's probably, you're probably able to sell the photographs if you can't really tell who's in the photo, but then in that case, people might not want it as
Right,
much as
yeah.
if they can see their child
These are
front and center.
action shots, they're not like,
Right.
they're not portraits, they're not.
Yeah, so if you can't really identify the person, then you've got a little bit more wiggle room, but ideally, you would use some type of photo release.
Okay.
Yeah, so you might be able to approach the parents and just explain who you are and just say, in the event that I sell them.
Mhm.
And most people would understand that if you make a couple dollars off of it, they're not gonna mind and they're gonna understand what you're doing, so.
So copyright, you claim it when you create something new.
It just sort of attaches, yeah.
It's not, whereas a trademark is something you have to register.
You have to use it, and you don't necessarily have to register it, but there's so many benefits to registering it federally that's usually our recommendation.
All right, so, but you wouldn't recommend, or can you even register a copyright to something?
You can register the copyright with the Library of Congress.
Oh, right.
Yeah, so you don't have to do that, but photographs, for example, you don't have to do each one individually. You can do a season, 2018, 2019, football season, and then that's just your collection. And you go on there and register the whole thing and attach everything at once. It's $35 to do the registration. Like I said, it's one of the few instances where I don't typically think an attorney is needed. Most people can do it by themselves. Because it gets a little expensive to throw attorney's fees in there. And then they ask you some questions, you upload the sample, and then you pay the money, and then you get the registration. So in terms of actually doing the registration, in a lot of cases, a lot of individuals aren't in a position to file a lawsuit to enforce something. So that's where the registration really comes in handy for the copyright. But if you want to do it the right way, then like I said, you can copyright the group or the collection. I have some clients that they've got a whole bunch of pieces and they don't copyright them, but they've got one that's near and dear to their heart, so they do copyright that one. It does allow you to send a cease and desist letter out to somebody. So even if you maybe aren't able to follow through on a lawsuit, you can send a cease and desist letter and say, hey, here's my registration. This work is identical. We do want you to cease and desist, using this image or poem or song or whatever it is.
Right.
So there are some benefits.
And a trademark you register, federally?
Yeah, you register the trademark federally. You can get state trademark registrations, but the federal trademark registration is so much stronger. The huge benefit to the federal trademark registration is that it is then valid across the entire United States and our territories. If you don't register it, then it's really only valid in the geographic area that you're using it in. So we've had clients that are starting out in Western New York, they've got their business. Meantime, somebody 5 states away, they file a trademark registration for the same name. Our client wants to grow, but they're really not able to because they can't get that federal trademark registration. So they're sort of stuck in the geographic area that they started in. So we've seen that happen a couple times. And we understand when businesses start out, they usually don't have any clients or cash flow. So to be hit with this additional expense is difficult. But we've seen people just not really be able to grow their brand because of that other trademark registration. So it is tough.
I have just an idea. I wanted to sell it to Twitter, like Twitter or Facebook. It's not like a product. It's just an idea.
Okay.
What's the first step I have to do it? I need to trademark or register my idea, or what do I need?
It sounds like, depending on what the idea is, it sounds like the only intellectual property available would be patent. It could be trade secret. If you keep your idea as a secret, then it can be covered by trade secret. But then in order to sell it to anybody, you'd have to have them sign a non-disclosure agreement. So they would sign the non-disclosure agreement, and then you can reveal the trade secret to them. It's still a secret because they're the only people that know it. And then see whether they buy it and see whether they don't buy it. That's, yeah.
Because I wanna sell it to some, like I go to the Twitter and Facebook also.
Mm-hmm.
I don't need to make a license for my idea, or
Well, you could license it, but the first step would be to have them sign the non-disclosure agreement, so that you can tell them what the idea is, and then it's still,
I have to speak with like Facebook or Twitter, or
yeah. Contact their,
because I don't want to publish my idea before I need to protect my idea first.
right.
After that, I will publish it.
Right, and then you can, the only way that it sounds like you can protect it would be through patent, if it's an actual invention. Is it a way of,
Like software? Or
Yeah, the
something that
software.
integrates
It's
into
like
Facebook?
software, but I don't make a software by myself.
Okay,
But
gotcha.
but it's the idea for the software?
yeah, it's an idea for the software.
So the first step would be to file probably a provisional patent application. So you describe everything that's going on and file the provisional patent application, and then you can try to sell it to Facebook or Twitter that way. So the provisional patent application, it gets you a filing date, and then you have to come in within 1 year and file a non-provisional patent application. So but it's a way to get, patent pending protection on your invention before marketing it or trying to sell it, and then you come back at the 1 year mark to ask for the full-blown patent.
So, say you have a publication that you plan to sell in hard copy, but you want to drum up some interest in it on the web first. You need to create a website for whatever, for that, or for your company, whatever,
Yeah.
and you put the stuff, parts of it, on the web. You should probably have that copyrighted and trademarked and such before you even put it out there in any way, right?
The copyright, not necessarily. You can probably put that out there. If you ever do need to enforce it, that's when you need to register it. It depends on, the copyright is, like I said, is fairly inexpensive, and it's fairly straightforward to file the application. So you can get the application on file and then publish it. And then in terms of the trademark, we recommend filing the application as soon as practicable. Just because if you've got a great name or a great slogan, people might start taking it right away. Just as an example, we advertised Pirate Fight Club on Facebook, and I applied for the trademark registration the next day. So, that's typically what we recommend, is to do it as soon as possible. For logos, it's maybe a little bit less urgent because it's less likely that somebody's gonna flat out steal your logo. They may take your name or they may take your slogan, but for the logo you might have a little bit of time.
Is that a separate application for that kind of stuff? Trademarking, you need to do one for like every element that you want to trademark?
Preferably. So Nike, for example, they've got the trademark for the word Nike, they've got the little swoosh, and then they've got their slogan, which is "Just Do It," which is separate. For some of our clients, they don't have the means that Nike has, so if they are using all three in combination, we will file an application with all three. But then what's covered technically is the combination. So when they use it separately, it's indirectly covered, but not the way that we'd recommend if they had unlimited resources.
Okay, well, this may be getting a little more detail than we want to get. But say you have a publication that has a title. You've got two characters in it. They each have specific names, not Joe and Mary. But, so you've got your publication, and they're always in your publication. But then they also exist as separate entities, and you want to license them somewhere. You want to make a T-shirt of this one or something like that. So they all come from the same place.
Yeah.
But
Names of the characters really can't be copyrighted, so they would have to be trademarked, but you'd have to be selling merchandise under that trademark. So if you think of Darth Vader, you can't copyright the name Darth Vader, but you can trademark it, and then you're selling Darth Vader, you know, accessories or pajamas or whatever they're selling. Mickey Mouse is the same thing. Most characters are, Harry Potter would also probably be trademarked. Most characters probably aren't trademarked, but then the bigger ones would be. So yeah, so that's something you could probably hold off on.
Is there anything about, like I have a blog or website with some of my work on it, so obviously this is like in JPEG form for someone to take and either share on their site or print it themselves. Like, do I have to go in and copyright every piece that I'm presenting or that I'm selling, or can I put some kind of blanket statement on my website saying like all rights reserved, or
Yeah, you can put
something?
the copyright statement on your website. And then that applies to everything that's on your website. In terms of the actual pieces, you can copyright those as a collection.
Okay.
So collection 2018, whatever you want to call it, and then put all the pieces in there. And then if you have more pieces later in the year that you create, you can call it, you know, fourth quarter 2018 collection, and you know, maybe wait till you get 50 pieces, copyright that collection, and then you can kind of do that and go along those lines.
What's the timeline on that?
The copyright?
Yeah.
Those come through pretty quickly. I think maybe
Well, as far as like from when it's created, that you have to register.
you don't ever have to
Oh, yeah.
register your copyright.
But if you wanted to.
If you want, you can do it whenever, you know, as soon as it's published.
Okay.
You can actually file a pre-registration for something that isn't published.
Is there a limit from after it's created?
No, you can file that whenever you want. If you need to sue somebody, you need to have it registered before the lawsuit.
Okay.
So you don't really, so if it's something that you really do want to protect, you kind of don't want to be scrambling at the last minute. But it's a strange area of law.
Is it retroactive? Like if you wrote it in 1998, but then you register it this year because you notice somebody might be in on your...
Well, that's a great question. You lose statutory damages from the time before it was registered. And the statutory damages are treble damages, which just stands for triple, but we're attorneys, so we have to confuse everybody and use the word treble instead. So there are some benefits to registering it early. You know, what you can do is maybe just get into the habit of just registering things every quarter or twice a year or something. Once you kind of go through, their website is really helpful. It's the Library of Congress Copyright Office. You know, you can go through there and read some of the stuff, and this is one area where you can kind of teach yourself, and then, you know, you do the registration once, and then you just put it in your calendar. Like I said, it's $35, so it's not a huge expense, and it might take you a couple of hours to get everything together, but it might be worth it just from the standpoint of doing everything the right way. And the other thing is that, you know, then you've got a copyrighted portfolio that you might be able to sell to somebody. Those copyrights actually last the life of the author and then 70 years, so it's actually something that you can pass down to somebody else, you know, when you die. This just got depressing. But you know, but it is something that could go into your estate, and you know, you never know, maybe you're famous and then you've got these really powerful copyrights, copyright registrations, or after you die, people realize how great your work was now that you're gone, and then so it could end up being something valuable.
So Bill, my advisor, was talking about, and I can't remember exactly what it was, but I want to remember it, or have you remember it for me. Coming downtown and doing a search for similar or exactly alike names.
Okay.
So you look them up, and if there's one, you know, maybe this is a trademark search or a copyright.
Yeah, it sounds like a trademark search.
All right, and you know, you want to make sure that you're not copying someone else.
Right.
Exactly.
Yeah.
So that is that he had spoken about coming down and flipping through all these old files and like that, or is that?
Oh, I know what he's talking about. He's talking about the DBA at County Hall.
Oh, okay. That must
Yeah,
be it.
so if you've got a particular name
Right.
that you want to use, you have to go flip through these books. It's kind of funny because my business partner and I, John Vecchio, we started out as a DBA because we started at the end of the year, and then at the beginning of the year we converted to an LLP. So we had to go through all of the books looking for Del Vecchio and Stadler, Stadler and Del Vecchio. And then when they were satisfied we'd done that, then we were able to do, the DBA as Del Vecchio and Stadler. But I think that's what he's talking about.
And so you're saying county hall, that is a county thing, or
Yeah.
what if there's someone else doing your same thing out in some other state or something?
Well, that's fine because the DBA is an assumed name, so it just gives you the ability to conduct business under an assumed name. So you're David, right?
Mhm.
Okay, so let's say you wanted to call yourself, I don't know, Snappy Cartoons.
Mickey Mouse Publications.
No, not that. Let's just say like Snappy Cartoons or something. And then you go through in Erie County. All that Erie County is doing is saying you may conduct business in Erie County under the name Snappy Cartoons.
Right.
So we're not too concerned about what's happening in Niagara County or the rest of the state or the rest of the country, because it's just Erie County that's recognizing you. So then if you decide to form an LLP or an INC, then you go to the state level, and then they do a search across the state to make sure that there aren't any other incorporations or LLCs calling themselves Snappy Cartoons. And then they may be satisfied, but if you want to register it at the federal level, let's say there
Right.
is a Snappy Cartoons in Kentucky,
Right.
then you're out.
Then you need to change.
Right.
I see.
So actually, in a lot of cases, if you start up a business, even before you file with New York State, you may want to do a U.S. Patent and Trademark Office search, because you could get a cease and desist
Right.
from somebody else, and then you spend this money on an LLC. You have
Right.
to go. You can keep the LLC and just change the name,
Right.
but then you're spending more money and more time and aggravation and.
So the U.S. Patent and Trademark search, how does that get conducted? Is that something online, or?
Yeah, it's uspto.gov. You'll click on the trademark side, you can do a search, and then you can do an exact search. You try to look up phonetic equivalents,
Uh-huh.
and anything that might be similar.
Okay.
So, the example I like to give is, you could go to New York State and form Nike Incorporated, but you're
Right.
going to get a cease and desist letter pretty quickly.
And if you find that it's not there, and you're cool, then you can do a trademark, you can register your trademark.
Right. And then of course we recommend an attorney for the trademark registrations as well. And so, we usually do a fairly quick search just to make sure that there's nothing glaring out there. But there are more extensive searches that can be done to
Mhm.
make sure that there's, nothing even close at all.
If the name of, say, your publication is a word or a thing that everyone uses every day, shovel,
Yeah.
that, you probably can't trademark that?
No, you can't trademark that
use
because
it.
it's considered generic.
Okay,
So
right.
you can't sell shovels in connection with shovels, because then you're preventing anybody else using it,
Right,
and that's no good.
okay,
So you can sell computers under the name Apple,
right.
but you can't sell apples under the name Apple.
Hmm.
And then in some cases, there's an exercise program out there called Pilates. It's actually become generic because everybody started using it.
Right.
So nobody registered it and prevented anybody else using it. So now it's generic. So yeah, you don't have to worry about generic. Ideally, what you come up with is something that's purely fanciful, like Kodak or Google. You know, before those trademarks, they didn't mean anything. That's not super easy to do, and everybody wants their business name and their business to describe what they're doing so people know. But I think sometimes it's nice to get people to think about stuff. I think there's like an orthodontic or a dental company around town called Owl. It kind of makes you think of it. What does an owl have to do with teeth? And then after a while, it doesn't have anything to do with teeth, I don't think. But then it's sort of stuck in your head. So you've gotten people to think about it, which it's more likely to stick in their head.